Hi, everybody. Thank you for being here today. ACS and BALSA are happy to co-sponsor this new type of event that Professor Aman has worked diligently to put together. I'm just going to briefly introduce Professor Aman. He came to our law school as dean in 1991 and worked in that capacity until 2002. He's a professor here who teaches courses on globalization and administrative law. He's been published in numerous sources and is going to be presenting today some of the interviews he conducted with Constance Baker Motley and Judge Tuttle about their work in the civil rights movement. So please join me in welcoming Professor Aman.
Thank you very much, and thanks for coming. Brown versus the Board of Education was decided in 1954, but its implementation was truly undertaken with all deliberate speed. Much of the litigation it spawned took place in the Fifth Circuit, which then included the states of Alabama, Florida, Georgia, Louisiana, Mississippi, and Texas. It has now been divided into the Fifth and the 11th Circuits. Brown was eventually extended and applied to many areas beyond education. What was effectively a system of apartheid, established throughout the South by the use of state laws mandating de jure racial discrimination, finally began to fall. This, however, did not occur without enormous resistance after Brown was decided. When I was in law school in the late 1960s, I was inspired by the creativity, courage, and political impact of a series of civil rights decisions, especially those decided by the Fifth Circuit Court of Appeals. The civil rights revolution had been long underway, and I wanted to be a part of it. I applied for judicial clerkships throughout the South, primarily to judges whose opinions inspired me. One day, I received a phone call from Judge Elbert P. Tuttle. He had been the chief judge of the Fifth Circuit Court of Appeals during much of this landmark litigation. He interviewed his law clerks over the phone to spare them the expense of a trip down south to Atlanta, where his chambers were. Much to my surprise, I got the job, and therein began two of the best years a new lawyer could possibly hope for. As I worked on a broad range of cases that came to that court, I seldom hesitated to ask Judge Tuttle about many of the cases I had only read about in law school. I was after the whole story. Who were the lawyers? What were they like? Who were the litigants? What became of them? Did some of the judges in these cases experience death threats? How did they handle that? Did the Justice Department back up the courts? Along the way, I also asked Judge Tuttle who, among the many great lawyers he saw in his courtroom, who impressed him the most? Without hesitation, he said, "Oh, that's easy. Constance Baker Motley." And much of what I want to share with you today is about her. When I began my academic career at Cornell Law School some years later, I taught first-year constitutional law. And after a number of years of telling my students Tuttle and Motley stories, I thought it would be more effective if I could bring them into the classroom via video. They had shared so many cases, but from different perspectives, with Judge Motley as the lawyer and Judge Tuttle as the judge. I also thought that each of them had an incredibly important story to tell. They both helped shape civil rights law in significant ways and for generations to come. I interviewed Judge Tuttle for several days in 1988. He was then 91 years old. I focused on his time as chief judge of the Fifth Circuit and his recollection of some of the famous cases in which he participated. All of these interviews are available for those of you who may be interested. I will be showing only a small fraction of what there is, and we'll show only one clip of the judge today. We could, of course, do a whole presentation on Judge Tuttle, but today we will focus primarily on Constance Baker Motley, a brilliant and courageous lawyer who argued so many landmark civil rights cases before the Supreme Court, in the Fifth Circuit, and throughout the South. Her physical courage and legal creativity provide us with an heroic example of what a public interest lawyer can be. I interviewed Judge Motley at her summer home in Connecticut, also in 1988. And she was then a senior federal judge on the Southern District of New York, having been appointed to that court in 1966 by President Lyndon Johnson. I was particularly interested in reviews on any number of civil rights cases, not only those in the Fifth Circuit and those that involved Judge Tuttle, but her long career as an attorney with the NAACP, a career going back to the 1940s. She was present at the creation, if you will, of the litigation strategy that culminated in Brown versus the Board of Education, and she helped make that decision a reality throughout the South. Constance Baker was born in New Haven, Connecticut in 1921, the ninth of 12 children. Her parents came from the Caribbean island of Nevis at the beginning of the 20th century. Her father worked as a chef for various Yale University student organizations, including Skull and Bones. Her mother was a domestic worker. Constance Baker was an excellent high school student, but never expected to go to college, much less law school. Her family simply could not afford it. In a feature story about her published in the New Yorker magazine in 1994, shortly, by the way, after Judge Motley had visited our law school, the author of that profile, Marie Brenner, recounted a speech that Motley had given upon her induction into the Women's Hall of Fame in Seneca Falls, New York. While other honorees talked about politics, Motley talked about education and the impact one person in particular had on her career. And here I am quoting from the New Yorker article. "There was no money for me to go to college," she said. "I went to work at the National Youth Administration, and one day I gave a speech at a black community house. Clarence Blakesley had built the community house. He was a contractor who had done a lot of work at Yale. He had made millions of dollars, and what he did with those millions was to help educate black Americans. Blakesley had been impressed by the teenager's speech and had asked her where she would attend college. When Baker told him that her parents could not afford to send her, he offered to pay for her education." Constance Baker traveled to Fisk University in Nashville, Tennessee by train, riding in a Jim Crow car. She said she was eager to experience segregation. Her parents were frightened for her. They themselves refused to cross the Mason-Dixon line. On her first trip home, she brought them back a colored-only sign. After 2 years at Fisk, she transferred to NYU and graduated in 1943. When Blakesley asked her what she wanted to do next, she said she had always wanted to go to law school. As she put it, "When I was 15, I decided I wanted to be a lawyer. No one thought that was a good idea." Luckily, Blakesley did, and he financed her legal education as well. And it is here that we pick up her story on our video.
Judge, I'd like to start with some questions about your own legal career and when you graduated from law school and what options you had and which career choices you made and what ultimately took you to the kinds of civil rights litigation that you participated in.
Well, even before I finished Columbia Law School in 1946, I got a job as a clerk with the NAACP Legal Defense and Educational Fund. Thurgood Marshall was the director counsel, and Robert Carter, who is now a judge on the Southern District where I am, was a new lawyer on the staff, and Edward Dudley, who was later a Supreme Court judge in New York State, was Thurgood Marshall's first assistant. And I was a law clerk. And when I finished Columbia the next year, I started in October 1945, when I was still a senior. And when I finished the next year, I just stayed on. And our first big case, if I remember correctly, was the University of Texas case that I worked on, and had to do with opening the law school at the University of Texas. And I think after that we branched out into a case in Oklahoma involving Ada Lois Sipuel, a young woman who wanted to go to law school there, and McLaurin, a graduate student who was black, who wanted to go to the Graduate School of Education. And those became the major cases which preceded the Brown decision. The Sweat case was the first case in which the Supreme Court actually ordered the admission of a black to a previously all-white institution. And the McLaurin case became notable for the fact that Oklahoma had finally admitted him to the graduate school, but required him to sit at a separate table and to sit at a separate table in the library and the cafeteria and that kind of thing, which the Supreme Court quickly struck down. And Sipuel, of course, was eventually admitted to the University of Oklahoma Law School. And those cases were in line with a program which the Legal Defense Fund and the NAACP had adopted at that time to attack segregation first at the graduate school level and then move down to the lower school level. So that, as I've said, those cases set the stage for the attack on segregation at the high school and grammar school level, which followed and culminated in the Brown decision in 1954. So there I was on the ground floor of what later became known as the Civil Rights Revolution.
So Constance Baker Motley was indeed on the ground floor and faced a daunting task as a new lawyer. She was seeking justice for individual clients who had experienced racial discrimination in the Deep South at a time long before Brown was decided. She was, in effect, setting out to desegregate the South, and the constitutional law she had to work with was embodied in a case called Plessy versus Ferguson, a landmark Supreme Court decision decided in 1896, upholding the constitutionality of state laws requiring racial segregation in public facilities under the doctrine of separate but equal. You can imagine how difficult it must have been to treat such a case as the law of the land, which it was, and which she, as a skillful lawyer, of course, did. She once remarked on a trip that she and her colleague Robert Carter, another young NAACP lawyer, who, by the way, like Judge Motley, also eventually became a federal judge in New York, and visited this law school several years ago. Well, they had to take the train to try a case in the 1940s, and this is what Motley said. She said, "I remember being infuriated from the top of my head to the tip of my toes the first time a screen was put around Bob Carter and me on a train leaving Washington in the 1940s. But this was the law as they found it, and their initial strategy was to use the separate but equal doctrine as a means to an end, a kind of doctrinal battering ram, if you will, really a means of abolishing segregation itself." So let's pick up with her further and more detailed reflections on those cases that were a run-up to Brown, her analysis of their litigating strategy, how many cases were around that ultimately ended up with Brown being chosen, and Brown came out of Kansas and out of the Deep South, and how that Brown litigation was put together.
The Gaines case, not the Gaines case, the Sipuel case from Oklahoma, the McLaurin case from Oklahoma, and the Sweat case from Texas. Well, those cases were coming before the Supreme Court right at that time. The Sippuel case and the McLaurin case from Oklahoma got there before the Sweat case, although the Sweat case was filed first in 1946. But the Sweat case had been filed in the state court. And at that time, as I recall, there were at least 3 levels of appeal in the state court system in Texas. And of course, the case dragged on for 4 years before it finally got to the Supreme Court in 1950. And in 1950, the Supreme Court, as I've said, ordered the admission of Sweat to the University of Texas Law School on the ground that Texas had hastily set up a school for him which was in no way comparable to the legal education afforded whites at the University of Texas. They pointed out that one of the essential ingredients of a legal education is an opportunity to discuss legal problems with future members of the bar that you'll be practicing with. And if you have nobody to talk to in law school, you don't get an education. And of course, he had 1 or 2 professors assigned to him and a few books and that kind of thing. And so that was a major decision for the NAACP and the Legal Defense Fund to have won, because here was the first real crack in the wall of segregation in education. Then the Sippuel case and the McLaurin case resulted in the admission of both of those students, Sippuel to the law school and McLaurin to the Graduate School of Education. And so the stage was set for a direct attack on segregation per se. Both those three cases were brought within the separate but equal context, because in neither Texas or Oklahoma had they set up separate facilities for blacks, as in the Gaines case. So with those victories, we then set about planning an attack at the lower school level. And I recall the many conferences that we had over a long period of time trying to decide exactly whether we would attack segregation directly. I remember Thurgood Marshall was asked that by the Supreme Court in the Sippuel case, are you attacking the concept of segregation per se? And he said no. Now, the reason he said no was because it was in line with our strategy of trying to break down segregation within the context of separate but equal, where the southern states were the most vulnerable. That is, they hadn't provided graduate schools for blacks. And to do so would have been very expensive for the southern states to duplicate a medical school or even a law school. And so we thought the South was most vulnerable at that level. And then, having gotten blacks in at that level of education, we thought it would be simpler to attack the lower school level, having successfully opened the graduate and professional school level without, we thought, incident. Well, of course, it didn't turn out that way. But anyway, the decision was finally made, of course, to proceed with a frontal attack on the very concept of segregation. And in the case brought in Kansas, which Robert Carter was in charge of, that was a case where we introduced the testimony of psychologists like Kenneth Clark and others with respect to the harmful effects of segregation on black and white children, and on which the Supreme Court relied in ultimately holding segregation unconstitutional in the Brown case in 1954. And if you recall, there were 5 cases filed at that time. Not all of them used that material. The one in South Carolina was filed before Judge J. Waties Waring, who, much to our surprise, ruled that segregation violated the 14th Amendment. And it was the state in that situation that had to appeal his case to the Fourth Circuit. In the Brown case, which arose in Topeka, Kansas, the judge ruled against us, saying that notwithstanding the testimony which had been introduced, segregation didn't violate the 14th Amendment. Then a case had been filed in Prince Edward County, Virginia. Again, that material was not used. It was just a direct attack on segregation as unconstitutional, a legal question, in other words. And then, let's see, there was a case filed in the District of Columbia. Now, all of those cases were brought to the Supreme Court about the same time. The one in the District of Columbia was still pending in the Court of Appeals for the District of Columbia, but the Supreme Court ordered it up before decision, as I recall, by the District of Columbia Circuit, so that all those cases could be decided together. And of course that surprised us, and we knew that the Supreme Court was ready to face the issue. And
Now, what was behind these multiple lawsuits? Was that part of your strategy as well, to have filed this kind of suit?
Yes. The thing that happened was that these communities had been preparing for this largely through the efforts of the local branches of the NAACP. They weren't cases that were just initiated, as the Southerners wanted to believe, by outside agitators. These NAACP members had attended NAACP conventions for years, in which the strategy was discussed and made known to them. They were told about what was happening in Texas and in Oklahoma. They knew about what had happened in Missouri years before, and they were ready to proceed. That is, they got the plaintiffs, the people who were going to act as plaintiffs, and that was no easy task, because particularly in the Deep South, there was a great deal of fear of reprisals on the part of blacks if they were the plaintiffs in such cases. So all of these 5 communities seemed to be ready to proceed. They had organized themselves.
It was a local
and
grassroots
yes,
kind of effort.
and in Kansas, it seemed that things would be easier there because it wasn't the Deep South, and then, as a matter of fact, segregation was permitted and not actually required in Kansas. But through custom and usage in the major cities, it turned out that there was extensive segregation. So Kansas, people in Kansas got themselves together and got 2 local lawyers, they were brothers I think, who then contacted the national office, and Judge Carter went out there and helped to prepare that case, and decided to try out this new evidence or new approach in that particular case. Fortunately, Kenneth Clark and others had been doing work in that area, so they were ready with their materials to proceed. And the cases were argued, I think the first time, 1952. And the Supreme Court did not decide the case on the merits. What it did was to issue an order directing the parties to respond to 5 questions, I believe it was, and to re-argue the case the next year, or that fall, something like that. And of course, that meant a great deal of work. And in preparation for that, a large number of lawyers were brought in to discuss the strategy, how the case should be argued in the Supreme Court. In addition, some of the questions required historical research, and so historians were employed to research the legislative history of the 14th Amendment and to write that up for us so that we could use that in responding to one of the 5 major questions.
Well, if step one of the Brown strategy was using the separate but equal doctrine to abolish the jury segregation, step two of their strategy focused on what to do now that Brown had been decided. Here, how and where should their litigation strategy focus? What impact should the Brown case have, and how might they control its application? As Judge Motley remarked, that case had such a profound impact psychologically and legally that they at the NAACP had to completely change their overall litigating strategy, even though it stretched their resources very thin. In her words, as you will now hear, a revolution had erupted, and we were there.
After Brown versus the board came down, and then specifically what your career was like after Brown, and the kinds of cases that you were involved in, and how you sought to have Brown applied in various areas and in various parts of the country, especially the South.
Well, when the Supreme Court ruled, of course, the decision was unanimous, and I think that was totally unexpected on our part. But then we realized the significance of that, and that meant that the Southerners would not have a second bite at the apple, so to speak. They wouldn't get a chance to re-argue, hoping that a new majority might change the decision. So we were very pleased about it, as well as startled to find that every judge on the Supreme Court had agreed that it was time to end segregation. Now, we knew that that would have far-reaching consequences, and as an organization, we were not equipped to deal with all of the consequences that might come. One of the things that we did was to try to map out a strategy for implementing Brown, and that is to start in the border states like Maryland and Kentucky and Missouri, where the resistance we felt might be less. But we could not control the forces let loose, so to speak, by the Brown decision. As you recall, by 1960, students in black colleges around the country began to sit in at department store lunch counters and were arrested for trespass and disorderly conduct and other offenses. And somebody had to represent them. And so the meager legal resources that we had as an organization in terms of manpower and funds had to be stretched in a new direction. Also, in Montgomery, Alabama, we suddenly had a boycott of local buses started by Rosa Parks, who refused to move to the back of the bus when she got on one afternoon after work, bringing in a whole new chapter in this struggle, that is to desegregate transportation. Now, in addition to school cases, the Legal Defense Fund and the NAACP prior to Brown had a number of cases involving transportation. There's a Boynton case in Virginia involving segregation on interstate buses. There was the Morgan against Virginia, which involved trains. Let's see, I've forgotten some of the others. But those cases were brought in an attempt to do away with segregation of Jim Crow cars, which was another major symbol in American communities of segregation. So we then had the freedom riders about the same time who were pressing this drive to eliminate segregation on local buses. Our concentration was largely on interstate commerce because we knew there was a commerce clause in the Interstate Commerce Commission, that sort of thing. But local buses was something else ordered by state statute. And despite our best efforts to kind of keep the whole desegregation program within our hands and some guide it and control it somewhat so that we didn't get bad court decisions and so forth, we could not do that. A revolution had erupted which we had not expected, and the Brown decision's greatest impact, I think, was psychological. That is to say that I think black people viewed the Brown decision as a statement by the Supreme Court that the Supreme Court was on our side. And although technically, of course, legally speaking, the Brown decision was limited to education, the layman didn't see it that way. The layman saw that as the Supreme Court striking down segregation, period. And so they proceeded to try to desegregate buses and golf courses, anything that had not previously been open to blacks. So that we found ourselves stretched pretty thin at that point. And then there was the rise of Martin Luther King with the demonstrations in southern cities. As early as 1961, I think, when he first marched in Albany, Georgia. I went down to represent him when the first injunction was issued against him in that case. That was one of the first cases, I think, that Judge Tuttle figured prominently in, because he, of course, lifted that injunction issued by Judge Elliott down in Maracus, Georgia. I think that's where he was located. And so we were all over the country, representing freedom riders, representing sit-inners, representing demonstrators, you name it. We were there. And after the Brown decision, some contributors who were not willing to contribute prior to the Brown decision, most notably the Ford Foundation, because they feared economic reprisal in the South, contributed in a major way to our financial resources, which meant that we could hire additional lawyers, which we did. When I started working with the Legal Defense Fund in 1945, there was Thurgood Marshall and two other lawyers, as I mentioned earlier, Robert Carter, who's now a judge on our court, and Edward Dudley, who became a New York State Supreme Court judge. And when I left in 1966, we had 25 lawyers on the national office staff of the Legal Defense Fund. And of course, we worked with at least 100 lawyers around the South at that time, whose cases many of the matters that we handled were, and who contacted us because of our legal expertise in handling school desegregation and other cases. So we were running all over the country and trying cases, arguing cases on appeal, taking cases to the United States Supreme Court. It seemed like every other month we were in the Supreme Court with another case. And from 1954 to 1964, the Supreme Court outlawed segregation in virtually every area, including segregation in courthouses in Virginia, I think was the last one in 1964. So that all of these cases leveled segregation in every area, and as I said, stirred the black community to action, which nobody seem to be able to do prior to that. There are a lot of people who claim the civil rights movement started with Martin Luther King and or somebody else later, but actually it's been a continuing thing ever since the Civil War, and the culmination of it was really the Brown decision, which got black people stirred to the point where they took charge of their own lives, so to speak, and branched out into many areas and gave Martin Luther King the foundation on which he stood in his determination to end segregation in local communities around the South.
One of the most famous and defining moments of the civil rights struggle involved the case of James Meredith versus the University of Mississippi, Ole Miss. In his excellent biography of John Minor Wisdom, one of the great judges of the Fifth Circuit at that time, or anywhere or any time for that matter, Joel Friedman writes, James Meredith was the sixth of 10 children. He left his family's 84-acre cotton and corn farm in Attala County in Mississippi after high school graduation to enlist in the United States Air Force, where he was one of the first black soldiers to serve in the recently integrated American Armed Forces. But the challenges and rewards of being in the vanguard of an integrated Air Force paled in comparison to the impact generated 11 years later when he integrated Ole Miss. In her superb biography of Judge Tuttle, Anne Emanuel writes, on January 21st, 1961, the day after John F. Kennedy was inaugurated president, James Meredith wrote the registrar of the University of Mississippi, requesting an application, a copy of the catalog, and, quotes, any other information that might be helpful to me. Over the next few months, the correspondence continued. Finally, on May 25th, the registrar informed Meredith that he would not be admitted. On May 31st, he filed suit in the United States District Court for the Southern District of Mississippi, seeking to enjoin the University of Mississippi and other state-supported institutions of higher education from continuing to limit admission to white persons. He also asked the court to enjoin the registrar from denying his admission for the summer term on the basis of race. Judge Sidney Mize set the hearing for June the 12th, but it was delayed many times. Finally, the hearing resumed on August 15th and concluded the next day, but of course the summer term was over. In his order, entered then in December 12th, 1961, Judge Mize found for the university, quotes, there was a good deal of testimony introduced in the case, he noted, but very little conflict, and the overwhelming weight of the testimony is that the plaintiff was not denied admission because of the color or race, or because of his color or race. The registrar swore emphatically and unequivocally that the race of plaintiff or his color had nothing to do in the world, nothing in the world to do with the action of the registrar in denying his application, close quotes. We pick up here with Judge Tuttle's recollection of this litigation. And you will notice how the appellate court sought to deal with the intransigence of the district court judge, as well as how the court dealt with the governor of Mississippi at the time, Ross Barnett. Though the Fifth Circuit voted to hold him in civil contempt, it should be noted that Judge Tuttle dissented. He would have held the governor in criminal contempt. Also note not only the levels of violence this case precipitated, but what kind of a show of force was ultimately necessary for the federal government to prevail.
That in the field of higher education, the state could not deny admission to a person on account of race. And the state of Mississippi made no bones about it. Well, I shouldn't say that either. They pretended that it wasn't on account of race. James Meredith was a veteran from the Air Force, and he'd taken a certain number of college grade courses while he was in the Air Force, and the grades were given by some recognized university. I think either the University of Maryland or something the Air Force had an understanding with, that their enlisted men could study under this process, and he got credits which would permit him to enter college or with some advanced standing. And he went to a black college in Mississippi. The name escapes me. And he spent a year or two there. Then he applied for admission to Ole Miss, University of Mississippi. And after a year's study of his application, they turned him down. So then he filed suit, alleging that he'd been denied admission on account of his race. Well, of course, the district judge denied the injunction that he sought, and he appealed to our court. And the panel of our court reversed the trial judge and sent it back to the trial court for further proceedings, saying that it's clear that he had been denied admission solely on account of race. And after they sent it back, the district judge, or I would say in the meantime, I think the state legislature passed a law that no person could be admitted to the University of Mississippi who'd ever been found guilty of a misdemeanor. Well, I think Meredith had been found guilty of driving over 40 miles an hour in some town or something, and they denied him admission on the grounds of that conviction of driving. He was not driving under influence, anything like that. So then he appealed again, and on the second appeal I was on the panel, and Judge Reeves and I think Judge Mize, who was the district judge it was a district judge from Florida, was on the panel. And I said we ought to enter an injunction right now, not send it back to Judge Mize, who was the district judge. Well, my colleagues wouldn't agree with me. I said if we don't do it now, he'll run out of time on his GI benefits. Well, they said, well, he can drop out for a term. Okay, we sent it back to Mize, and then I think at any rate, Judge Mize then found that he had not been denied admission on account of race, and that there was no policy in the University of Mississippi for whites only. And that was appealed. And then I remember Judge Wisdom wrote the opinion, and he said it would be a big surprise to the people of Mississippi to realize that Ole Miss was fully desegregated. In any event, he read to me on the telephone the order that he planned to enter. And I said, John, I think there's one thing I'd add to that. I would recite the exact order and direct the district judge to enter the order as written. So he called me back and read the order, and he said, the district court, on remand, the district court shall enter the following order. I said, all right, now there's one other thing. Add this paragraph. Until the above order has been entered and fully complied with by the defendant is hereby enjoined from denying him admission. So we issued our own injunction. So far as I know, that's about the first time the Court of Appeals had ever issued an injunction. So then, of course, the state ignored the order. He applied for admission, was denied. So then he brought a complaint asking us to hold the Board of Regents in contempt for refusing to obey our order. And then I announced that it was time that the United States Justice Department got into the case. And it's time that we made the governor a party to the litigation because he had publicly ordered them not to admit him. So we made him a party. And then we enjoined him from participating in any denial of admission.
Judge, how did you make the governor a party?
I don't know, we just made him.
Or did the court itself, or did one of the plaintiffs move?
My recollection is the court itself stated that the governor will be given a proper notice that he is now a party to this litigation. I'm not sure about that. And he did not object to that. Of course, he was happy to be made a party because he was looking for publicity. So then we found him in contempt because Meredith, the governor, the legislature then took from the Board of Regents the authority to admit students and gave it to the governor. Then the governor, Meredith, went to see the governor, of course with his lawyer, and demanded admission, and the governor denied it. So we then found him in civil contempt and ordered him subject to civil contempt of $25,000 a day until he obeyed the order of the court. So then there was some maneuvering between the governor and the Justice Department, and they finally had some kind of agreement that Meredith would appear on the Oxford campus, and they would put up a show of denying him admission. But if Meredith was accompanied by a sufficient show of force, they would let him in. So he went through that, and they denied him admission. So then...
Even with a show of force?
Yes. There was not enough show of force or something. Or the governor reneged on his promise, I'm not sure. I wasn't a party to that, of course. And then the government, incidentally, I called Bert Marshall in open court. I asked Bert Marshall to stop by in my chambers after the hearing. And when he came in, I said, Mr. Marshall, I'm going to give you some military advice, not legal advice. We're going to enter an order one of these days very soon. And I want you to know that if we order Meredith admitted, the government should be prepared with sufficient force to be sure that our order is carried out. And I said, don't use marshals. Use military personnel with rifles and bayonets, because nobody knows how sharp those bayonets are. And if you go into the campus accompanied by a military force, you'll get him admitted without any trouble. Well, of course, he ignored that, and they had 400 marshals on the campus. And when Meredith came in, he actually went to another building other than the one where they thought Meredith was coming in. The marshals gathered around this building, and the marshals and the mob were fighting all night long with gas, gas grenades and that sort of thing. Several marshals were injured slightly, not very seriously. One or two people were killed by some kind of occurrences, I'm not sure what. And but Meredith ended up admitted after all that night of violence. And then the violence still continued, and then the government had to order the 101st Airborne Division, 18,000 men down there to do away with the violence. Whereas if they had sent out maybe a company of infantry armed with rifles with bayonets affixed, they'd have had him in without any trouble at all.
In Jack Bass's book, Unlikely Heroes, he writes that barely 3 weeks after the court's order in the Meredith case, quotes, Mrs. Motley was awakened at home by a 4 a.m. telephone call from a black grocer whose family had housed her in Mississippi during the Meredith case. From her caller's tone, she knew immediately something terrible had happened and thought Meredith had been killed. Instead, she learned of the slaying of Mississippi NAACP leader Medgar Evers, shot in the back from an ambush as he stepped out of his car to enter his home in Jackson. We now pick up with Judge Motley reflecting on the Meredith case, the history of civil rights in Mississippi going back to Reconstruction, the special brand of resistance that seemed to thrive there, the violence this often involved, and her sense of what it must have been like to be James Meredith at the time.
When you go to Mississippi today, especially at the university, it's as if nothing has happened. It's a beautiful, quiet campus. I went, well, a few years ago. It was the 20th anniversary of the admission of Meredith, and they had a program at the law school, and I went, and I was surprised that the place was so beautiful. I had never actually seen it, and got to see the campus and that kind of thing, and they had several successful black graduates from the law school. I've forgotten how many they had in the undergraduate school at the University of Mississippi, but they had a number of graduates in the undergraduate school, and everything was peace and quiet, as if nothing had ever happened there. And of course, the white students that are there now have no idea what it must have been like at that time. I noted that a man named Silver died very recently, who was in the thick of it, and I think he had written a book about the situation. But there were people on the campus who, were opposed to the action of the governor, in the sense that they were for upholding the law. And they saw a hard time because there were not enough people in Mississippi who were willing to speak up. And I guess Mississippi was always the most difficult state for blacks. I remember as a child growing up, hearing stories about Mississippi, how the way black people were treated, and that kind of thing. And it was many years later when I learned on my own, just by reading, that during Reconstruction, for a period of time, black people were in control of the state government for about 10 years during Reconstruction. And when I was in Mississippi, during that period, I heard that the records for that 10-year period were under lock and key, and nobody could see them. It was as if it had never happened. As far as the people of Mississippi were concerned, those records were not available. I think they have since been made available to, historians and scholars and others. But that 10-year period was not a part of Mississippi history as far as the whites were concerned. I remember during the sit-in cases, I think it was, when we did research on the Civil Rights Act of 1875 that sought to guarantee blacks equal accommodations in public places, and I was reading the legislative history of that act, and I discovered that there was a black congressman from Mississippi in the Congress at that time during this Reconstruction period, whose name was John R. Lynch. I knew there was a Lynch Street in Jackson, Mississippi, because that's a main thoroughfare in the black community, and I thought it was named after the fact that blacks had been lynched, but actually it was named after this black congressman, and most blacks in Mississippi didn't know that, never heard of John R. Lynch. because I asked them about it. They didn't know who John R. Lynch was. John R. Lynch was in the Congress representing Mississippi at the time of the proposed enactment of the Civil Rights Act of 1875. And he made a speech on the floor of the Congress, which I read in the Congressional Record, in which he said that he thought the law should be enacted because when he left his home state in Mississippi to travel to the nation's capital to participate in the Congress, he was denied accommodations in Tennessee and Kentucky. And he said, we don't have that in Mississippi. In Mississippi you could stay in the hotels, but I can't stay in the hotels on my way here to the Congress. And then there were others in the Congress. There were a couple from South Carolina. One was a man named Robert Brown Elliott, who was a lawyer, and who was reputed to be the ablest black lawyer in the country at that time. And he debated some colonel or general in Alabama who was reputed to be the leading constitutional lawyer of the day. He debated him on the constitutionality of the Civil Rights Act of 1875. Now, South Carolina was another state that was under the control of blacks for 10 years, and Robert Brown Elliott was a leader in that, the government at that time. That's how he got to the Congress. He was almost elected lieutenant governor of South Carolina. But South Carolina and Mississippi were the two states, I believe, that had majorities in the legislature during Reconstruction. In South Carolina, the whites just refused to participate in the formation of a new government after the Civil War. And I suppose the same thing happened in Mississippi. So the only people available or willing to reconstruct the government were largely blacks, and some whites who had gone there from the north, and I guess a few whites locally. And that's how blacks managed to be in control of state governments in those two states for a 10-year period. And I think Mississippi was the one state where the majority of the people were black. I think it was something like 51% black and 49% white for many years in Mississippi, until maybe as late as 1950. I don't remember the precise date when the figures were reversed. But Mississippi has always had this huge proportion of blacks in the population, which led to greater suppression of black rights. And they certainly remembered the period when blacks were in control of the government, which they were determined would never happen again. And so that's why Mississippi was the most repressive with respect to equality for blacks all through its history. And now even that has changed. We have a black congressman for the first time since Reconstruction. There's a black man who's a state court judge. There's a federal judge who's black in Mississippi. And I guess there are several in the state legislature. I don't know the exact number. And as I've said, there are several black graduates of the law school who have positions in the state government. So that this change in Mississippi has really been tremendous, because it was the state that was the riskiest to go into to try to, enforce rights. And it was a place where Medgar Evers was killed, of course, as a result of his activity, and others who had been killed, like Emmett Till before that, who was accused of some crime or something like that. But it was really a place to be afraid for one's life. I remember talking to Medgar Evers many a day about his being careful when he came home at night. I stayed with a black music teacher who taught in the county, not in the city of Jackson school system. So she wasn't afraid to have us stay in her house. There were no black hotels in Jackson that you'd want to stay in. and so I stayed with her, and Medgar used to come over, and of course in the evening we'd talk. And he lived on a street where there were new houses, relatively new houses, in the black community, and the streets were unpaved. And in the middle of the road, just outside of his house, was a fork in the road, and a bush had grown up there. And we used to say, Medgar, somebody could stand behind that bush, so you have to be careful. He said, oh yeah, I know. I always look before I get out of my car, because his carport was right there, adjacent to this bush. And he had to go right by it every night. And 2 years later, I guess, having dropped his guard, was when this man was waiting to kill him. And that was the tenor of the place. I mean, there were people there who were out to actually kill. You know, the 3 young men who were killed in Philadelphia, Mississippi, who went there to participate in some voter registration campaign. They were killed by an official, you see? So that it was really a frightening place to be. And I remember when Meredith was waiting to be admitted to the University of Mississippi, all during the trial, he used to walk with a cane. And at first I thought, well, you know, he needed the cane because he was in the service. I thought maybe he was injured somehow. So when we got ready for trial, I said to him, now Meredith, you should get a blue suit and a shirt and tie, because he was wearing his army fatigues, they call them. He wore those every day. And that's because he didn't want to spend any money on clothes. He was the thriftiest person you ever want to meet. But anyway, and I said, why are you carrying that cane? Because then I realized he didn't really need the cane, because in the house he just walked around like everybody else. So I said, and don't bring that cane. Why are you carrying that cane? And you also have to shave off that beard. He had a beard. I said, you have to shave off the beard and get a suit and leave that cane. So I said, why are you carrying that cane? He said, well, that's for protection. I said, protection? I said, here you are in a black community and you need protection? He said, yes, because they'll hire a black man to kill me. And so he walked with that cane until the trial began, because he feared for his life. Now, can you imagine walking around for a year and a half thinking somebody's going to walk up behind you and kill you? And that's what he went through, that kind of stress. So much so that I thought, you know, he just couldn't last, you know. But he finally made it out of there. I don't know how he was able to study, you know, under those conditions, but he finally got out of there and graduated. I didn't go to the graduation because shortly before that was when Medgar was killed, and I decided my 9 lives had run out.
When one looks at successful legal and judicial careers like Judge Motley's and Judge Tuttle's, it's easy to think that they were inevitable, that somehow it had all been foreordained. How could they have done otherwise or failed to succeed? Of course, nothing is further from the truth. Judge Motley and Judge Tuttle took courageous risks for justice. They could only hope to succeed. They had no pre-approved blueprint or a roadmap that was guaranteed for success. All of us as lawyers never really know for sure if something will work or not, especially as we try new things and use our legal creativity to imagine and then help implement what might never otherwise have been. We conclude now with Judge Motley's description of her very first case and the sense of hope it engendered in her and all who knew her. And this will be the last clip, and we will leave the last words to Judge Motley.
Well, the first time I walked into a Southern court was in Mississippi, in Jackson, Mississippi, in 1949. That is a case in which I actually participated. I sat in on a case in Maryland, tried by Charles Houston, which opened the nursing school at the University of Maryland to blacks. And Thurgood Marshall had sent me down to sit in with Houston so that I could learn how to try cases. And I have never forgotten that experience, because he was one of the best trial lawyers, I guess, in the country at that time. He had every question he was going to ask written out in a notebook, and never departed from his prepared questions, and his exhibits all prepared and that kind of thing. And it was really the only education I got in actually trying cases. We didn't get that in Columbia Law School. They didn't have clinical courses in those days, and they certainly didn't have civil rights courses. But anyway, Judge Carter was the chief counsel in a case in Mississippi in 1949 for the equalization of black teachers' salaries. Now, this is long before Brown, and this was an area also in which the Legal Defense Fund had done an extensive amount of work, again within the separate but equal context. That is, they brought suits to equalize black teachers' salaries, because black teachers were uniformly paid less than white teachers to teach the same subject, so to speak, in the South. And Mississippi was one of the places where nobody wanted to go, even then, for fear, again, of economic reprisals. But the teachers in Mississippi, the Black Teachers Association, raised the money because a black lawyer locally had to be paid to file the suit. None of us were Mississippi lawyers. And even in the federal court, we could be admitted, but a local lawyer had to sign a complaint, and somebody who had been admitted. And in those days, we found a black lawyer who lived in Meridian, Mississippi, who signed the complaint, and the Teachers Association paid him $1,500 to do that. That was a lot of money in 1949 in Mississippi. But that's all he did in the case. And we went down, Judge Carter and I, to get ready for the trial, to prepare our witnesses and that kind of thing. And we had employed a statistician from Atlanta, a black man, to do the statistical analysis of the qualifications of the teachers and their salaries and their assignments and so forth. And we had to go over that. We were there for about 10 days before the actual trial. The trial started on a Monday afternoon. I'll never forget it. We walked into the courtroom and it was packed and jammed. Every seat was taken. And the thing about it was that those who were lining the walls were all black, and the whites were seated. And Judge Carter told the blacks after the session that day that there was no segregation in the federal court, so they could sit anywhere. In the state court, blacks had to sit in the balcony or in the back or something like that. So the next morning at 9 o'clock, when the case resumed, we got to court, and the blacks had gotten there early, and all the seats were taken by blacks. So the question was whether whites were going to stand while black people sat in a public place, something which had not happened in Mississippi in this century anyway. It may have happened during Reconstruction when blacks controlled the state, but not in 1949. So what the judge did, Judge Mize, he apparently directed the bailiff to open the huge doors to the courtroom and leave those doors open so that the whites could parade by and see the Negro lawyers from New York, as we were called. They couldn't say Negro, they would say Negro lawyers. And the local paper that day had written up the fact that one of these Negro lawyers was a woman from New York. and so that brought out, I guess, an even bigger crowd, because they had not seen in Jackson, Mississippi, any lawyer in court in this century. And they certainly hadn't seen any black women lawyers. In fact, they hadn't seen any white women lawyers, for that matter. So it was quite an attraction. So the case proceeded each day as white people paraded by to see these two black lawyers from New York. And James Burns was the name of the man from Meridian who was the lawyer who signed the complaint. Now, James Burns, I said, even at that time, was 1 year older than God, and he had grown up in Mississippi. I don't know when he passed the Mississippi bar. He really did not practice law. He didn't go to court. I think what he did largely was probably real estate transactions and deeds. And he did that in his grocery store as a part of that activity. And I remember the first day we went to court, he wasn't going to examine any witnesses or anything. He sat with his back to us at the counsel table, making notes, and he made notes the whole time with his head down, just making notes. I think the man was fearful of what might happen to us, you see. He had never experienced anything like this in his lifetime. That is, black people challenging the system in the same way that the whites would challenge the system, by taking a case to the federal court, which, like in many communities, was something most people weren't even aware of, you know. And they certainly never had any business with the federal court. And all they knew it was the United States government, and that was something different. So he sat there the whole time writing notes. And at lunchtime, at dinner time, he'd disappear. You know, normally lawyers on the same side of a case would go out to lunch and dinner together. We were all from out of town, but he always disappeared. And the second day of the trial, Bob Carter said to him, go outside and see if our witnesses are out there. And he got up from his seat and bent over with his head almost to the ground, walked out, you know, in deference to the court, so to speak. In other words, he didn't want the judge to think that he was doing something for which he should be reprimanded, walking out of the court. So he wanted to demonstrate that he was being humble, as black people were expected to be. And he went outside and came back and said, yes, and the witnesses were outside. And every time he had to go out, he went out in that fashion. I couldn't believe it. But anyway, the last day of the trial, when it was all over, he said to me, because Judge Carter wasn't speaking to him by that time, he said to me, you know, I'd stay and have dinner with you all, but I have to go home and bring in the wood. My wife is sick, and I have to bring in the wood, you know, for the stove. And so I said, oh yeah, I understand. But he went out the very last day standing erect, like a human being walked out of the court when he had to go out to see whether the witnesses were there. Now the reason for that was that the judge, Mize, acted like one would expect a federal judge to act. He treated us courteously. He addressed me as Mrs. Motley, which the lawyers didn't do. And he ruled with us on many motions and objections. Now his final decision was against us, But as he wrote in the opinion, the only reason that he was against us was because the Fifth Circuit had just ruled in the case from Atlanta on the same subject that you had to exhaust administrative remedies before you brought such a case in the federal court. This was a 1983 case. Now, 20 years later, the Supreme Court ruled you didn't have to exhaust administrative remedies, but here we were in 1949 being thrown out. And he found, of course, that the blacks were uniformly paid less and that we had otherwise prevailed. Now, during the trial, for example, when the superintendent was on the stand, he was speaking in his low southern style manner, and Judge Carter got up and said, Your Honor, would you please ask the witness to speak up so I can hear him? And the judge said, yes, speak up so the lawyer can hear you. Now, to everybody in the courtroom, particularly the blacks, they had never seen that before. That is, a white man telling another white man to speak up so a black man could hear him. And that night, Judge Carter said he went to the barber shop, and everybody in the barber shop was reenacting that scene. They thought that was the greatest thing that had ever happened. But again, you see, Mr. Burns, who walked out like an animal, gradually straightened up when he realized that there was a forum in Mississippi where black people could take their cause and be heard. Even if the judge ruled against you, he had not known that in Mississippi a black man could go to court and be a lawyer like any other white man and be respected. So that was my first experience in a Southern court.
Well, thank you all for coming, and I hope you have had a chance to get to know these people a little bit, experience their personalities, as well as learn some of the things that they did. I don't know if anyone wants to, if there's any discussion or not, but I think Judge Motley's last words were pretty powerful, like a human being. Thank you.